Hello, everyone, and thank you for coming to this webinar and for those who will listen later. This is a webinar on work visa options after OPT and life after the H-1B lottery. Many people are wondering what the current status of the H-1B lottery results are. We are as well. USCIS previously indicated that they are done entering all data in for the winners of the lottery, and we are still awaiting to receive any of the rejection notices. So far to date, we haven't received any. Um, so there may still be hope out there for those interested. However, with one caveat, it's been a few weeks since we've received at least any of the receipt notices. But that's not to say that some might not still trickle in as we continue. So this webinar will focus on the options for students who are graduating now, who have applied for their OPT for the next year, but also those who have had their OPT for almost a year and maybe are waiting with bated breath until the results come in. We're going to talk about, though, as well, the various options available to folks, including H-1B, but this will focus more on those options other than H-1B. These slides will, as we progress, we'll cover the basics, but I'm going to talk about what this means for individuals as we go through. As of the basics for students, you're all familiar with the rules for CPT and OPT. Individuals who are currently enrolled in an academic program, subject to approval from their international office, are eligible for CPT if they will be working in their field of study um, through some arrangement with a outside employer or a cooperative agreement that that employer has with the school as a part of the established curriculum. And then there's also optional practical training, OPT. This can be pre-completion and post-completion. And if it's post-completion, you have to wait until you get the EAD card in hand. There are specific rules about when and where you can apply for it, and we'll briefly touch on those, but I want to get to the substance of today's presentation. Generally, there's also the STEM OPT extension, and this is one of those potential forms of relief for individuals in an appropriate field. The STEM list is included here. This is the website where you can track down the current list of approved academic courses or academic programs which qualify for STEM. So it's not just that your field of study is somewhat related to science, technology, engineering, or mathematics, but is actually directly related to, or excuse me, is actually listed on there. On your I-20, there will be the program number. The program number must correspond to a program on the STEM list. What this means for folks, really, if you're at the end of your OPT and you're unsure of the results of the lottery as of now, what are your options? Well, if you haven't yet gotten onto a STEM OPT extension, it may be worth considering if you're eligible for it. Number one, your program would have to be on that STEM list. Number two, you'd need a job offer from an employer who is enrolled in E-Verify. That's one of the biggest, things that people sometimes miss whenever they're considering a STEM OPT extension. The actual employer must be enrolled in E-Verify, and when you apply affirmatively for the STEM extension on Form 765, included with it must be the proof that your employer is registered in E-Verify. Speak with your school's international office first. They're the ones who can tell you whether or not your degree is included on that list if you're unsure, if you can't, figure out where to find the list yourself, and whether or not that job is actually related to your major. The employer themselves would provide you with the evidence that they're enrolled in E-Verify. All this should be given to your school's international office to request the ever important I-20 endorsed for post-completion OPT STEM extension. The STEM OPT extension is valid for a 17-month period, so that's a total amount of OPT for 29 months. It's not a 29-month extension. It's a 17-month extension of your current OPT. One second, please. OPT carries with it certain responsibilities that you should all be aware of, especially for those of you who are awaiting confirmation of the cap and may be approaching the end of your OPT as on the card. OPT unemployment periods. If you're in your 12-month OPT post-completion regular period, you have up to 90 days of unemployment. You cannot be unemployed for more than that time. This includes if you're not in the U.S. So if you were outside of the U.S. for a certain period, and obviously not working in the U.S. as a result, that can count against you. For the STEM extension period, that 17-month portion, you get 120 days. How do you avoid unemployment? You can volunteer. You have to, be doing at least 20 hours of work in your field, 20 hours of work per week in your field minimum. There are different, various avenues of volunteering. You can also speak with your school's international office about this, as they may have some additional ideas or suggestions. The most important thing for those who haven't yet done so about applying for OPT, if you were a recent graduate now, you're already past the 90-day period prior to the program end date, but you may still be within the 60 days after the program end date. You also must apply and really get the entire application with the I-20 endorsed for OPT from your school's international office into the hands of USCIS within 30 days of the issuance of the I-20. So if you asked for your I-20 endorsed for OPT but have not yet applied, check the date on the I-20, because if you are on day 29 right now, well, it must be received by USCIS by tomorrow. So it's not just when you mail it, it's whenever it's actually in USCIS's hands. So check with your school and check with your school's international office about ensuring that if they do have to reissue an I-20, that there's a specific process they have to do within SEVIS to do it correctly, so that there's no issues with the actual date that they recommended OPT. The date that's in SEVIS it may not necessarily be the same date that is the I-20 date if it was reissued, because you can reprint, but then you can also reissue. If you haven't yet applied, my suggestion would be to apply and apply as soon as possible if you're still within the period of time within which you can. OPT, once you receive the card, you can't work until you actually have the card, allows you to work in any position for any employer as long as it's related to your field. So it permits you avenues to develop your career outside of the context of the H-1B cap. Now, of course, as the title of this presentation suggests, the H-1B will be a centerpiece in this. The information contained in the next few slides covers the basics of the H-1B. I will go over it briefly, but I want to get to the next most important piece of what else. So it's a professional occupation visa, which means it's a job that requires a minimum of a bachelor's degree in a specific field of study, and you have at least a bachelor's degree in that field, or related field, or the foreign equivalent. If you are a student or a recent graduate from a U.S. institution of higher education, you are looking at this from the perspective of graduating from a bachelor's degree. So if your bachelor's degree is in a specific enough field and the job is one that requires a bachelor's degree in a specific field, for example, the ones listed here, then you can qualify for an H. However, it's not that easy, as many of you know. The H-1B lottery is the biggest headache involved in the process. There's only 65,000 visa numbers available per fiscal year. The fiscal year runs from October 1st of the, so October 1st to September 30th, and that means 6 months prior, the earliest you can ever apply for an H-1B is April 1st. So that's the traditional opening of the H-1B cap season. This April 1st, overall, and during the first 5 business days of April when the cap was open, approximately 233,000 H-1B petitions were filed. There's only 65,000 spots, minus a few set aside for another subset, visa classification H-1B1, which we'll talk about, for individuals who are citizens of Chile or Singapore. So the odds do not look good. That's less than a 30% chance, approximately, of being selected in the H-1B regular cap. Now, there's also 20,000 H-1B numbers set aside on top of that 65-ish number for individuals who have at least a U.S. master's degree. And that U.S. master's degree must be from an institution of higher education in the U.S. as defined by a specific law that has requirements of what that quote-unquote U.S. institution of higher education is. So basically, that means private for-profit colleges typically will not qualify for that. So it's important to check with your school's international office on whether or not they are, in fact, meeting this definition before next year you file for an H-1B under that master's cap. If you file under the U.S. master's cap, but you were not actually eligible to file under that master's cap, you may run into problems with adjudication of that petition should it be selected in the lottery. So just be aware of that. Here's a kind of historical rundown of the various cap seasons. On April 1st, 2009, for example, was the opening of the fiscal year 2010 cap. As you might remember, back then the economy was not doing so well, and a lot of people were hiring, including not hiring H-1B workers. What that meant was that the H-1B cap was not even met until December 21st, 2009. So it took a long time to be reached. The next year, for fiscal year 2011, it took even longer. The economy was still languishing. We saw some improvement for the following year in November, and then it was the summer of 2012 when things started to turn around. The H-1B cap opened on April 1st, 2012, and then was met in June, on June 11, 2012. So we saw some dramatic improvement. In anticipation then of the April 1st opening of the 2014 cap, USCIS anticipated this and confirmed they were going to likely receive more petitions than available spots. So the economy is improving, people were hiring again, and they were right. The cap was met within the first 5 business days of April, and they conducted the first lottery in a few years. This has been the case for the past couple years, including this most recent year. In the April 1st to April 7, 2014 cap season, that's for last year, fiscal year 2015, there were roughly 172,000 H-1B petitions filed for the 65,000 spots under the regular cap and the 20,000 from the master's cap. This year, like I said previously, there were approximately 233,000 H-1B petitions filed for a very limited number of spots. We can do the math, and as a matter of fact, the next slide does. That's not a very good chance of selection. If you were filed under the U.S. master's cap and you qualified for it, if you filed under that, they actually conduct the master's cap lottery first. So they go through all of the petitions that were received, and they enter in the data and assign it a number, and then they randomly select those that were filed under the master's cap. They select 20,000 of those. Once those are selected, the individuals who were not selected in the master's cap lottery are then waterfall down into the regular cap lottery. So those individuals had two different lotteries within which they could have been selected. We did notice that a lot of the first receipt notices coming in from this year were for individuals who filed under the U.S. Masters cap, and then the regular cap cases, receipt notices started coming in after. That it was not a complete mutually exclusive period of time, but we did note that that was the order in which they tended to come. Like I said earlier, it's still possible that receipt notices could be trickling in, but we haven't received a receipt notice for a few weeks now. One helpful way you can check to determine if your petition was accepted in one of the lotteries. Let's say you didn't get a receipt notice, um, but you're still waiting and you're curious. Well, the filing fee checks that were used, and this doesn't work all the time, but sometimes does. The filing fee checks that were used to, or rather submitted along with the petition, if they were issued by your employer or your employer's immigration counsel, sometimes USCIS will stamp the receipt notice on the reverse image of the check. So if those checks are visible through online banking, for example, then it might be possible to access the reverse image of that check if it was cashed. So you could see potentially a receipt notice, a WAC number or an EAC number, depending on where it was filed. If it was in California, it's WAC. If it was in Vermont, it's EAC. And that receipt number then you can enter into USCIS's online case status update website portal and access at least get the basic information. If it shows that it was an I-129 petition and we, received the filing fee for your I-129 petition, that is a good indication, but not necessarily dispositive or not necessarily proof that you were selected in the lottery. If that's the case, if you haven't received a receipt notice, but the receipt number, in fact, does appear on a cash check, and that cash check was used for the H-1B filing, it may behoove you to call USCIS customer service and ask if they have the correct address for petitioner where they would send the receipt notice or for petitioner's immigration counsel. That's just one possibility, and it doesn't work all the time because sometimes people don't have access to the reverse images of their checks, and sometimes just things happen. But nonetheless, that's one option to potentially see if there's been any movement. If there are no checks cashed in your case so far and no receipt notice received, while we're not calling it impossible, it may be unlikely that it has been selected in the cap. So what happens after that? And right, here's the math that I spoke of earlier. Approximately 148,000 petitions were not selected for adjudication this year. We haven't received any rejection notices yet, and that will be important for those who are currently on OPT when I talk about the actual cap gap relief process. So cap gap relief, for those who haven't yet filed for an H-1B but are going to next year, maybe you're starting out on your OPT now. If you're starting out on your OPT now, then and you had an employer file an H-1B petition for you, chances are, it's not impossible, but chances are you didn't have the OPT card yet. So the cap gap wasn't really applicable to you because your OPT expiration date will be your program end date. You're still in duration of status. For those on the tail end of the OPT, though, who may be having OPT card expiration dates sometime during the summer between April 1st and September 30th. Those individuals are the ones who, upon approval of the H-1B petition, let's say it was selected and approved, your cap gap extension applies, meaning your duration of status is automatically extended to September 30th. And if you had OPT active, the expiration date is automatically extended to September 30th. Now, what about everyone else whose petitions either have not been um, confirmed received or confirmed rejected yet? Well, if your H-1B petition was filed as a change of status from within the U.S., meaning it was to affirmatively allow you to remain in the U.S. Up to September 30th in F-1 status, and on October 1st, the start date would have had to have been October 1st, automatically change to H-1B. Well, if you haven't received the rejection notice or a receipt notice yet, but your petition was filed correctly as a change of status like that, and cap relief would have been available, then right now your your F1 duration of status and OPT are still allowed to proceed. You are still in the cap relief. If your date, if your OPT expiration date has passed, but you still have not received notice from USCIS, you can still assume that you have the cap relief until, and that's the magic point, once you receive notification of rejection, once you receive notification from USCIS that your petition was not selected in the lottery, the affirmative notice of non-selection, that is then the date that you would have to stop working unless your OPT is still valid until X date. So you then have a 60-day grace period from the date of notice of non-selection within which to either depart the US or extend your F1 via another program or change status to something else. Obviously, it wouldn't be H-1B because it was not selected, but that's when your grace period starts. So the grace period then is determined to start from either notice of non-selection or the program end date, whichever is later. So, for example, if your OPT card expired on May 1st and you received your notice of non-selection today and you had an H-1B cap petition filed for you to change and extend your status, as of the receipt today, your OPT would end. Your cap OPT extension is over. You would have to stop working and you have a 60-day grace period from today. If your notice of non-selection came today, but your OPT expired July 1st, then July 1st, since it's later, would be the last day you can work, and your 60-day grace period starts from that date. So I know that's a lot of information, but nonetheless, that is the rule for how the cap relief works for people who are not selected. The magic period of time is, the magic date is the date of notice of non-selection. For individuals who were accepted or rather, their petition was selected in the lottery and is now pending with USCIS. If your petition is denied at any time, that would be the same as if it was the notice of non-selection for OPT cap relief and F1 cap relief. If your OPT expired May 1st and you received a denial notice today, your work would have to stop today and you would have a 60-day grace period from today. If your OPT expired in July 1st and you received a denial notice today, then you may continue working pursuant to your OPT unless the denial notice specifically says otherwise. This is an outline of the process for individuals on how cap relief works. So, it's a visual summary of pretty much what I just said. For individuals who are looking to do potentially an H-1B petition next year, either because you just started on your OPT or are about to start on your OPT, you have that year to work through it. If you had an employer file an H-1B petition for you this year and it either wasn't selected or it was denied, you may, in fact, have another bite at the apple next year. You just can't have more than one H-1B petition filed for you by the same employer each fiscal year, but they may refile next year, or another employer can file next year. Or, if you had two completely different job offers willing to sponsor you for an H-1B, which is something you would want to consider and have full disclosure, just as a matter of ethics, to each of those different employers. But nonetheless, you could technically have two filed for you if they were completely separate employers. All was on the up and up, and there was no, funny business, quote unquote. I'm not going to go through the H-1B process today. I don't believe that it is directly applicable to this webinar. But nonetheless, these slides will be available for download afterwards should you wish to review any of this specific information. This all talks about the H-1B issues for small employers and just the process in general. But just know that, and this is what we're going to get into now, that the other options besides H-1B for individuals. The first and foremost thing to consider is whether or not the H-1B cap even applies. So, for individuals who previously held H-1B status in the US in private industry. So, if you've previously gone through this cap process, if you were one of the lucky individuals who, in that historic chart I showed you earlier, had a petition approved during one of those previous caps, and come October 1st of that, applicable fiscal year, you actually did work for that employer, or at some point you worked for that employer, and then you left the US. And then, however, you now have a job offer in the US, and they're willing to do an H-1B. Well, if you were already counted in the H-1B cap and you have time left on your 6-year maximum of H-1B status, then you may be eligible to have a cap-exempt H-1B petition filed for you to recapture that time that you never used. So if you worked for 2 years for an employer on an H-1B, left the U.S., and then a year later get a job offer back in the U.S., and it qualifies and everything else is fine, that petitioner, that company rather, could file a cap-exempt petition for you to recapture the unused time and ask for up to 3 years of the remaining 4 in H-1B outside of the cap process. You don't have to go through and wait for that April 1st cycle to take advantage of your remaining H-1B time. You had to have worked in H-1B status in the U.S. So it doesn't count if you were approved for an H-1B but never worked on it or never used it. That happens sometimes whenever people were, maybe during their OPT cap gap extension, circumstances changed and they left the U.S. and never actually worked here past that October 1st start date. Also, if you have a job offer from a cap-exempt organization, so this is not about you, this is about the petitioner. Institutions of higher education, so colleges and universities, the nonprofit organizations affiliated with them, and research organizations affiliated with those institutions of higher education are cap exempt. The definition of cap exempt is very specific, and so you must, make sure that the petitioner is in fact cap exempt, but those institutions more likely than not already know it and can help you. So the job offer with an organization that is cap exempt means you don't have to go through the April 1st filing cycle and you won't be subject to that lottery. However, it's important to note if you did previously hold H-1B status in the US and you were working for a cap-exempt employer, but you get that job offer a year later from a company in the private industry in the US, which would otherwise be subject, you do not get to take advantage of recapturing and coming in. If you move from a cap-exempt employer to a cap-subject employer, you do in fact have to go through the H-1B lottery process. The cap does not apply to H-1B extensions or changes of employer. So if you change jobs from one H-1B private industry company to another, you don't have to wait for the next cycle or lottery. And as a matter of fact, you would be able to start working for the second or subsequent employer upon the filing of that petition. You can have multiple H-1B petitions and multiple H-1B employers at once. And after you started in the H-1B October 1st lottery time. What that means is you can have part-time H-1B you can have multiple H-1B employers at the same time. It's called concurrent employment. Um, all these are, kind of nuances about the H-1B, and so are these next few slides. I will briefly mention, though, the H-4 spouse rule, that as of May 26th, individuals who have H-4 spouses are now eligible to apply for employment authorization documents or unrestricted work permits, so long as the person has reached a certain point in the green card process. So for individuals who are in the cap lottery slash adjudication period now, and you're not starting an H-1B yet, your spouse doesn't qualify yet. They're not in H-4 status yet. And even more so, you would have to have reached a certain point in the green card process in order to let them apply for this EAD. So it doesn't really apply here. But nonetheless, know that going forward, H-4 spouses who are in the U.S. currently and their spouse, the H-1, has actually reached that certain critical point, would be eligible to work in the U.S. with an unrestricted work permit. USCIS's stated goal for implementing this new program was to make the green card process a little bit more attractive to foreign nationals and try to keep, the world's best and brightest talent here in the U.S. So, without further ado, the other options. Like I mentioned earlier, if you are a citizen of Chile or Singapore, then there's another H-1B1 visa available to you. If you have a job offer in a specialty occupation, you qualify to perform the duties of that occupation by way of your at least a bachelor's degree in the specific field required, a related field or the foreign equivalent. You actually get to not only skip the H-1B lottery process, you get to skip USCIS altogether. H-1B1 visa is available for issuance from the Department of State directly. So you apply for the H-1B1 visa directly at the embassy or consulate abroad, with proof of your citizenship of either Chile or Singapore, and then everything else that would come with it, including the labor condition application and the support letter, etc., your qualifications. But you don't have to go through the lottery, and you don't even have to go through USCIS. So that is a nice option for individuals from those countries. In addition, the E3 visa for individuals from Australia. If you're an Australian citizen, you would be eligible to apply directly at an embassy or consulate abroad for the E3 visa, similarly with all the other evidence. You don't have to go through USCIS, and you don't have to go through the H-1B lottery. H-1B1, there's a numerical limit on those. It is not usually, in recent memory, to my knowledge, ever met. But it's around, I think 1,000 or 5,000 respectively. For Australian E3s, there's about 10,000 available each year. And again, that cap has never been met in recent memory. The TN NAFTA visas for Canadians and Mexicans. If you're a citizen of Canada or Mexico and you have a job offer in an occupation that is specifically listed in the appendix to NAFTA, and those include things like engineers, that can be software engineers, mechanical engineers. There's many different occupations listed. Google that appendix number, the 1603.D.1, occupations NAFTA, and you will see the list. Canadians who do not need visas to enter the U.S. may apply affirmatively for TN status directly at the border or at a pre-flight inspection point with Customs and Border Protection. The H-1B1 and the E3s have a limited duration. The E3s are for 2 years, and the H-1B1 is either for 1 year or 2 years. I don't recall off the top of my head, so I don't want to give you the wrong info. The NAFTA TNs, the Canadians may apply for up to 3 years at a time at the border, and Mexican citizens can apply for TN visas directly at the Department of State. The TN visas for Mexican citizens, however, Due to reciprocity agreements or arrangements, I should say, between the U.S. and Mexico, will be limited to a validity period of 1 year at a time. So they would just have to be renewed each year. Um, One other point though, TNs, you don't have to go through USCIS, but you can. So if you're a frequent international traveler and sometimes would be out of the US for more than 30 days at a time or traveling to multiple countries at a time, um, without an approval notice from USCIS, each time you come to the US border or pre-flight is a new application. So it's a longer process, so it's slightly more expensive, $56 instead of 6. But if you have a USCIS approval notice for TN showing that you're classified as TN for up to 3 years, it smooths that process and makes it a little bit easier. Now, we're getting into some of the other alphabet soups of the temporary work visas. And also, I just want to note, if you have any questions, feel free to type them in, and we'll get to as many as we can at the end of this process. And if we don't get to your question, we can follow up after the presentation or incorporate it into the next webinar. So the J1 program, there's many different subsets of J1s. They can be for, researchers, postdocs, a lot of different things. But the two most common are the trainee and the intern. The trainee is for individuals who have 5 years of work experience outside the U.S. or have a foreign post-secondary degree or certificate and 1 year of experience outside the U.S. So as you can see, the trainee is not going to be an option for individuals who are just graduating from a bachelor's degree program from within the U.S. More specifically, the OPT post-completion training program, there's a very, there's a lot of hesitation among J1 program sponsors for issuing the J1 equivalent of a I-20, which is the DS 2019, for individuals who have already been working in OPT in the U.S. for some time. More often than not, too, it just doesn't really add up because they probably don't have that post-secondary degree or certificate from abroad or 5 years of work experience prior to coming to the U.S. for a bachelor's degree program. But that's not necessarily the case for people here in a master's degree program. Maybe someone did have, and often people do have, that requisite work experience or education and experience abroad. The trainee program usually lasts for no more than 18 months at a time. The intern, J1, is for individuals who are either currently enrolled in a foreign academic institution or have recently graduated from one. So, for individuals who may be watching this webinar who were not recent graduates of U.S. Bachelor's level or master's or higher level education, maybe just did a certificate in the U.S. or something similar, but nonetheless, or maybe are just outside the U.S. and this may be an option for you. However, if you're in the U.S. in OPT or are a recent graduate, there are rules about applying for the J1 which require you to first return to your home country, your place of last residence abroad, and maybe even wait there for a certain amount of time before you apply for the J1. The J1 can be about a 4 to 5 month process just to apply for it, get it, and come back to the U.S. And that because they're also limited, the interns to 12 months, the trainees to 18 months, keep that in mind if you're even considering this as an option, if you think you may qualify. If you have specific questions about the various J1 programs, program sponsors, I would also check out the Department of State's website about, study in the U.S. There's a J1 section, but also you should be wary of and look into whether or not coming to the U.S. in J1 status is something that you would be, in the long term willing to do, especially if you would become subject to what's called the 2-year home residency requirement. And the 2-year home residency requirement applies to individuals who have been in the U.S. in J1, who either receive government funding for the purposes of international exchange, who, whatever the skill or area that you'll be studying for the J is related to, is on the list, what's called the quote unquote skills list for your country. Um, this skills list is available in the Department of State's website for each country, and it lists the various fields and areas and occupational kind of classifications, specialties, I should say, which may require the individual to return to their home country for 2 years. And the purpose is to facilitate this international exchange, to apply what they learned in the U.S., either about U.S. business practices, U.S. specific fields of study, or if it's if it, for example, a Fulbright program, which is paid for by the government, would automatically be subject to the 2-year home residency requirement. Individuals who are subject to the 2-year home residency requirement may not become H-1Bs or adjust status to green card unless or until they've either fulfilled the 2-year home residency requirement or obtained a waiver. So that is something to consider and make sure before you even go down the path of J1. Here's some other categories too. The J1 professor research scholar. It depends with institutions of higher education. Postdoc scholars are often in this. Likely, I would talk with your international office, the students and scholars section, and or your faculty advisor if this is something that you'd be interested in. Unlike the F-1 or M-1 programs, unlike the F-1 program, which carries a 60-day grace period after the program end date, the J-1 has a 30-day grace period at the end of the program. So if your J-1 DS-2019 end date is May 31st, you have 30 days from that day during which you may not work, but you may either extend if you have time left on your J. Overall, if you change status to something else, assuming you're not changing to an H and subject to the 2-year home residency requirement, or adjust status, file to adjust status, assuming also not subject. So just keep that in mind. Unlike the H-1B or H-1B1 or E3, which have no grace periods, the J-1 does. The H-3 trainee is another potential option. However, it also requires you to return to your home country to apply for the H-3 visa before coming back. Unlike the J-1 trainee, the H-3 trainee goes through USCIS first. The J-1 you apply for directly at the Department of State after you work with the program sponsor, submit an application for them, etc., to get the DS-2019. The H-3 doesn't have a similar I-20 or DS-2019. You get an approval notice from USCIS. There's no cap or lottery associated with the H-3, but there are very, very particular and strict rules about the H-3. You have to be doing training which is not available in your home country and will benefit you in your career abroad. Now, that sounds like a generality, but you really do in an H-3 petition with USCIS have to prove that this training is not available in your home country. So for example, if you will intend to work for a company abroad and they have a corporate affiliate in the US and this training is specifically only offered in the US and they don't have someone who travels abroad to do it, that's an option. No productive hands-on employment unless that which is incidental and necessary to the training program. So, for example, you can't just sit down and start doing the H-1B level work you would otherwise be doing. It really does have to be classroom specific, lots of review, lots of structure kind of training program. This can be, there is a limit where you can have it for up to 2 years, but if you reach the 2 years, then there is a home residency requirement. So 18 months is pretty much the max that we've seen realistically be able to be approved for an H-3. The reason for that is it's tough to substantiate in an entire H-3 training program unless you really have a whole binder of something already created, showing the amount of classroom instruction and hands-on work that you'll be doing under close supervision. And it can't just be straight up work. It has to be, incidental and necessary to the training program. Like, Unit 7, we're going to learn how to do regression analysis and or use pivot tables and apply it to these clients' finances. So that kind of thing. There has to be some measurement and some reporting structure. And you also have to demonstrate you have a residence abroad you have no intent of abandoning. Um, to help show that it will benefit your career abroad, um, if you can show that there is a shortage of this type of training or occupation in your country, be it through expert reports or something similar, that may do. The best evidence would be, a job offer from someone saying, in your home country, saying we want this person to complete this training. Upon completion of the training successfully, if there's a test at the end or some certificate at the end, then we will absolutely hire them. So you can't go straight from the OPT though and change status in the U.S. to H3. That is not permitted. And if you're ending the H3 training program and then you have an H-1B petition filed for you the next year, for example, if it's that same employer, then that you may run into some issues with USCIS because they may see that as, well, was this actually fraud? Did you intend to employ this person the whole time, as opposed to help facilitate their career abroad? Nonetheless, sometimes things do change during a training program, and they say, you know what? We would love to give them a job offer, but we still want them to finish this training program and go abroad and do it. But we're keeping that option available. Speaking of corporate affiliates and subsidiaries, if you have at least 1 year of employment abroad with a corporate entity related to a U.S. company within the past 3 years, and that your employment abroad was executive, managerial, or specialized knowledge, those are very specific subsets, and there's very key requirements of what they are. But if that is the case, if you have a year, and it can be in the aggregate, and it has to be full time, of employment abroad in one of these qualifying capacities, and you have a job offer in the U.S. with a related entity in an executive, managerial, or specialized position, then you may qualify for an L1 visa. L1 visas typically go through USCIS first, and then upon approval, you can apply for the visa abroad. There's no cap and there's no lottery. However, adjudications of L1Bs are the most highly scrutinized of the visa categories. As a matter of fact, I think visa denials in the L1 category were L1B specifically were somewhere upwards of 30 to 40%. USCIS has recently put out proposed draft guidance on what they define as quote unquote specialized knowledge positions, but just be aware of that. L1As have a maximum of 7 years. L1Bs have a maximum of 5 years. So, that's just generally something to consider if you are looking to come to the U.S. One of the benefits of the L, which I didn't mention about the Australian E3 as well, but spouses of L1s are eligible to apply for employment authorization documents or EADs, unrestricted work permits, when they're here in L status. So spouses get L2s. The E3 category for Australians, the spouses are also allowed to apply for work authorization. So in the E3 context and the L context, you do not have to reach a certain point in the green card process to get the EAD like you would in the H category. So there are some pluses and minuses of these other categories that are somewhat different than the benefits associated with the H. One of the other benefits associated with the L that is similar to the H is you're specifically permitted to have dual intent. So you can have the temporary intent to work here, but the longer, more abstract intent to remain. But even more so, you are allowed to even have a green card process ongoing for you, and it would not affect, your ability to continue in that status or travel internationally and come back. You don't have to prove at the border that you have a residence abroad you have no intent of abandoning. You don't even have to necessarily, prove that your intent is temporary so to speak, because if you have an I-140 or a green card application pending for you, it won't cause problems like it could in every other non-immigrant visa context. So, H-1Bs, usually build up to a perm labor certification application or something similar. The L1s, the L1A specifically, it builds up to a green card application in the EB-1-3 or EB-1C category, which is for multinational managers and executives. We can, if you have questions about that, you can ask specifically afterwards, and I can go into those details, but I want to cover all the basics first. So the E3 was a special carve out for Australians, and it was issued after, I believe, the Second Gulf War, because they joined the Coalition of the Willing and a number of other agreements. But beyond that, there's also the E1 and E2 treaty trader and treaty investor visas. These are for individuals who are coming to the U.S. to either, conduct trade with, or rather between the U.S. and their home country, or are coming into the U.S. to invest in either starting a new business or purchasing a new business, but they have to be coming to develop and direct that business themselves. Now, I say themselves as if they're the owner. So if you are the owner of a company and you're coming to the U.S. to either open up a new office or purchase another one and expand into the U.S., you have to invest a substantial, quote unquote, amount of capital into this company, and it has to actually be invested. It can't just be money in a bank account into things, like inventory and equipment and personnel and so on and so forth, physical premise. What's substantial? Well, that's the biggest question. It depends. There's no set number anywhere in the law regulations, but what is substantial is enough money to actually make the business work in a realistic way. So this is in regards to the E2. So if you're coming into the U.S. and you're purchasing a aerospace, factory that designs engines for airplanes, I don't think 150,000 would be substantial because I don't think you could actually conduct that business with only $150,000. If you're investing, a couple billion, perhaps, maybe, or million, but it depends on every specific case is the point. Generally, the minimum threshold for cases is somewhere around $75,000 to $150,000 of tangible investment, and that's for things that are very basic, that do not necessarily basic, but do not require a lot of specific capital investment or a lot of overhead. Service-based companies may qualify with that amount of investment in the outset. For the E1 treaty trader, this is for individuals who are coming to the U.S. to carry out that specific trade, import-export. At least 50% of that trade must be between the two between the two countries. You can also have E1 and E2 employees. So as long as the employee shares the nationality of the E1 or E2 owner or trader, then and they're coming to fulfill, a supervisory, managerial, or a specialty position, then they can apply for those. Now, the key, though, is that there must be a treaty between the U.S. and that country. So the Department of State does have a list on the internet. You can Google it, but if you're not sure, you can ask us. There's about, roughly, I think, 35 or 40 or so countries on this list that can qualify, and not every country has both an E1 treaty and an E2 treaty. But for example, Australia does, Japan does, France. There's a number of countries that do. I can tell you that China does not have this treaty. Brazil does not have this treaty. So it's important to know whether or not the treaty exists before you even go down this route. Now, I also mentioned that the owner the owner of the enterprise, right? The outside investor has to be a national of a treaty country. So, because, as the Supreme Court said in recent years, corporations are people. A corporate entity, if it has the nationality of that country, can be the owner, can be the investor. So, there are many different ways that an E1 and E2 can work. Startup companies, this is usually how individuals can facilitate starting a business in the U.S. if they're from a treaty country. Um, Bringing it back to OPT and why that's relevant, you have an unrestricted work permit with OPT. You can you have a lot you have a lot of leeway. You can even work for yourself as long as it's related to the field of study. Take advantage of that and build up. Individuals who jump into E1 or E2, you have to show that there's actual tangible investment or business operations and along with a business plan, but having something already in place, having a business already up and running to some extent, even if it's still in the red, but you have a pretty solid business plan to show that in a few years it will be out. That is something you could start and get on board with while you're in OPT, and then once it's ready, perhaps change it over. For individuals not on OPT or whose OPT is expiring or about to expire, including because of the cap gap, if you apply for what's called a B1 intending investor visa from abroad, you may be able to come to the US to carry out specific business activities related to getting your company ready to be run. You can't do the hands-on productive employment of running it, but you can do things like negotiate the contracts, find a specific place, get the lease agreement, do the signing, negotiate with partners on pricing, getting things in place like that. That's often a method people use to get the company into a position to be to submit the application for the E1 or E2 prior to actually starting an E1 or E2 status. Spouses of E1 or E2s are eligible to apply for unrestricted work permits once they're here in E1 spouse or E2 spouse status. So that's another consideration to keep in mind. And of course, this would have been helpful while I was talking about it. Nonetheless, the slides will be available. The other options involve the O1 for individuals of extraordinary ability or achievement. There's the O1A and the O1B. Individuals who are in the fields of science, education, business, or athletics get to apply for O1A. There are different criteria and different requirements you must meet versus the O1B, which is for individuals in the arts or in the fields of motion picture television. So these individuals must show that they have extraordinary ability or achievement, sustained recognition for achievements, really in both categories, O1A and O1B, that you're at the top of the field. It involves, if you have press about your accomplishments, if you've won awards for your achievements, or, have served as a judge of the work of others. Now, this means outside of the student context. So if had student awards, they're not completely ignored in the O1 category, but USCIS takes the position that they discount those because the individual was a student and doesn't really reflect on their profession outside of that context. O2s, this may be another option for individuals. You haven't had the opportunity really to develop your portfolio yet or your list of achievements or CV resume, post graduation. Again, that's why you use your OPT to the fullest extent possible. But in the O2 category, if you have worked with, you have prior experience with someone who's in an O1, in some fashion, you've worked with them before, and you will be assisting them in their performance. So this comes into play for the arts, for example, for studios, for post-production studios, or for musicians, or for even advertising agencies. individuals who have had some experience with someone in the US in an O1 and will work for that company as well alongside them and only alongside them. Um, and you're key or you're essential to the performance, then you may qualify for an O2. An O2 is a very another specific subset, but it may be an option if you're working with other individuals that you know are an O1. So that's something to consider if you don't yourself yet qualify for an O1, but are going to be working with them closely and exclusively. An O2 may be an option. O3s is the spouse and children category for the O, and there's no work authorization available for that category. Um, here's some of the types of evidence that can qualify to help qualify someone for an O1. If you think you may have, um, a nice, concise portfolio, CV, a list of accomplishments, get your press together and take the time while you're an OPT to really fully develop this. Any mention of national, for example, doesn't have to be U.S. national. So if you have national acclaim or national awards from your home country, that qualifies as national, and so that meets the criteria. You have to be coming into the US, however, in all of these situations to continue working in that field. I don't want to spend too much time on it because I do want to touch on the kind of second half of the immigrant overall process. There's the alphabet soup, and then there's actual immigrant visas or green cards. Um, Individuals who are from countries without extremely high immigrant visa applicants are eligible to apply for the green card lottery each year. There's roughly 50 to 55, depending on the fiscal year, of these green cards available. Now, out of all the people that apply, they select roughly between 75 and 100,000 each year because they know that a certain number of people who will get selected in the lottery won't in fact actually complete the visa application and or don't really qualify for it. So there's a lottery within the lottery. If you look on our website under the publication section, under articles, there is a good article about, the lottery within the lottery, what comes next after winning. So I'd say check that out. I would say absolutely if you qualify and you're from a country, get in the green card lottery, submit your lottery ticket. If ever asked if you've ever applied for an immigrant visa and all you've done is enter into the green card lottery, you are not affirmatively applying for an immigrant visa. You are just simply buying a lottery ticket. And by buying, literally, it just means submitting and getting one because there's no application fee. So apply for the green card lottery. You never know. Um, it's based on your country of birth is an important distinction, not necessarily just the country of citizenship. So watch out for that. Here's a list of the countries that are not currently eligible in the green card lottery because of high immigration from those countries. You can also cross-charge and take advantage of your spouse's winning the lottery and applying. But you don't affirmatively apply for the green card visa unless or until you've actually been selected in the lottery. So just keep that in mind. It does not affect your ability to obtain non-immigrant visas in the U.S. And of course, there are family-based options if you have U.S. Relatives, including an immediate relative. If it's an immediate relative and you're in the U.S. and they file a application for you, you may be eligible to adjust status, or you could immigrant visa process from outside the U.S. Children cannot sponsor their parents unless or until they're 21 years old. So if you have a U.S. citizen child, that does not help you until they turn 21. The other categories I'm going to skip over for now, and the employment-based categories. The EB1, first preference. There's EB1A or EB11, aliens of extraordinary ability. This is really the green card version of the O1. Now, there's no requirement that you be in the U.S. in a non-immigrant visa status before applying or before having someone petition for you in one of these immigrant visa contexts. Just bear that in mind. Often some people think, well, I have to be here in an O or an H or an E or an L before I can do this. No, that's just usually how it works because a U.S. employer, knows after working with someone for several years that they'd be willing to sponsor them for a permanent work visa, excuse me, permanent immigrant visa, permanent resident status. EB-1-2, outstanding professors or researchers for, individuals who work for institutions of higher education. The EB-1-3 or EB-1C is the green card version of the L. So the same criteria would apply for that. The most common for individuals graduating from U.S. Institutions of higher education in a bachelor's or master's right now, or for individuals outside the U.S. With at least a bachelor's degree or the foreign equivalent, or a master's degree. A bachelor's plus 5 also could qualify. But here's the EB2 and EB3 categories. Now, the perm-based is the most common of EB2 and EB3 immigrant visas. If you have a job offer that requires a bachelor's degree, then, all else being equal, it would be an EB3 position. If it's perm-based, whether it's EB2 or EB3 depends on the job offer, not upon your qualifications. You still have to qualify for it, whatever it is. But if you have a master's degree, but the position only requires a bachelor's, or a bachelor's, plus like 2 years of experience, that's not enough to get it to EB2. Just because you have the master's does not put you in that category. However, there are two other EB2 options worth mentioning. The national interest waiver for individuals who have had some demonstrable impact on the field as a whole. They'll be coming to the U.S. to work in a field of intrinsic merit, and their employment will benefit the U.S. beyond just, prospectively benefiting. So if it's in the national interest, so if your work is pretty substantial and you have had some, demonstrated impact on your field, and this doesn't just have to be in the sciences or in research. It can also be in business. It can be entrepreneurs. It can be individuals who've created jobs abroad and or in the U.S. and better in the U.S. because then you have more to show that you've had a demonstrable impact on the field as a whole. There's no premium processing available for national interest waivers. Just keep that in mind. So they can take a few months to process, and RFEs are pretty common because it is quite a small group that will actually qualify. But an important distinction, the EB-11 and the national interest waiver, those two are self-sponsored. You don't need a U.S. job offer. You don't need a U.S. petitioner in order to apply for those two categories. The Schedule A Group 2 EB2 is for people of, either because they have an advanced degree or they have an exceptional ability in the arts, science, or performing arts. And the Schedule A Group 2 is specifically referring to a list of occupations of which there is a shortage in the U.S. So they are and would be exempt from the PERM labor certification application process. That can be beneficial for individuals who have less time on their hands to work with. It still takes at least 5 months because of all the requirements of posting the notice in the workplace, and it's very for a small subset of occupations that actually qualify in the arts and sciences and also performing arts. Most everyone else is going to be EB3, and that's perm based for individuals who have a professional job offer or non-professional job offer, and just it's a skilled worker position. The distinction between EB1, EB2, EB3, EB4, EB5 mainly matters because of the wait lines, the Department of State Visa Bulletin. The Department of State issues every month what's called the Visa Bulletin, and it shows who's qualified to now finally, it's basically like the counter at the supermarket. You may now apply. We're now serving these people. EB2 in most cases is current right now, whereas EB3 is somewhat delayed, but the Department of State has moved those visa numbers up very far. Right now, I believe for July, which was posted yesterday or the day before, it shows that EB3 is they're currently allowing people to apply for green cards whose priority date is in April of this year. So it's not that much of a backlog right now. So it's pretty beneficial. This may retrogress in the future. This means that the date may go back. The priority date, by the way, is the date that the actual perm application is submitted to the Department of Labor if it's perm based, or the I-140 petition is filed with USCIS, depending on the process. And of course, it's definitely worth mentioning that there's much uh, higher wait times for individuals from China and India right now. I believe that the India EB2 category might be backlogged as far as almost a decade. It changes very often, and individuals from the Philippines currently are unavailable, meaning they've oversubscribed for the fiscal year and are not adjudicating any petitions as of right now, and also for July for EB3 individuals from the Philippines. I won't go through the perm process here because we ran out of time, but if you have questions about the perm process, you feel free to ask us. And of course, there's the EB5 program, which is outside the scope of this presentation. We have multiple webinars throughout the year on the EB5 program. It's the investor green card. It's either $1 million into an enterprise that you will develop and direct, and or the 500,000, soon probably to be 800,000, as there's a current legislation pending in Congress, um, into a regional center in a targeted unemployment area. I won't go into that though. We've run out of time, unfortunately, so I won't be able to answer any questions. However, I will respond to questions via email if you submit them. Here's my contact information, so please feel free to send me any questions you have. And thank you very much for your time and